So,
Liz, just maybe you want to use the mic because we're being recorded. Sound is being captured.
I can't do this.
Okay,
I have,
sorry.
sorry, I'm missing my third arm. So I've never been accused of being soft-spoken, so can any of you not hear me? Everybody can hear me, that's, okay. Other than the camera, so. First, a health warning. We're covering today European data privacy and data protection matters and how AWS can assist you as customers and controllers in achieving compliance requirements under those laws and regulations. There are a myriad other compliance obligations that you will have. For example, if you're in a regulated industry, financial services, for example, you'll have obligations to your financial services regulator. You may also have legal requirements that apply in the specific country where you're operating. You also may have compliance obligations that you need to comply with under contracts that you've entered into with third parties. For example, if you're a PaaS provider, you may have agreed by contract with your customers that the data that they provide to you will not be stored or transferred to outside of a specific region. So just keep those in mind. Again, we're just talking about privacy and data protection, a lot of other stuff that you need to comply with that we're not talking about today. So I'm going to start out first with a discussion of where we are today in terms of legislation, some key concepts in data protection legislation. I'll then turn over to discuss AWS and the AWS model, including the shared security model. And then we'll circle back to, again, address the key concepts and how it all fits together with the AWS services and the AWS model. At the end, we'll talk about the GDPR. I know that's a topic at the forefront of many people's minds, and we'll get to that and what AWS can help you with in that front. So, today, we are operating under what's referred to as the directive. The full formal title is the 1995 European Directive on the Protection of Individuals with regard to the processing of personal data and on the free movement of such data. Again, it's referred to as the Data Protection Directive, sometimes just the directive. The directive, as a directive, it had to be implemented in each member state via national legislation. And the principles of the directive have been implemented in all of the European member states. And although those laws all originate from the base directive, there is significant variation among the member states' substantive and procedural data protection laws. As an example of this, a lot of member states only have one supervisory authority. There's a member state that has 15 supervisory authorities. The aim of the GDPR is to harmonize all this so that by crossing the border within Europe, you don't all of a sudden have a different regulatory landscape with regard to data protection. Whether that will happen remains to be seen, but that's the aim of the GDPR. So key concepts. These concepts also exist in the GDPR, so worth keeping in mind. It's not something that will go out of date once the GDPR is implemented. Data controller. So the data controller is responsible for protecting personal data from unlawful processing. And the data controller must ensure that if it outsources processing, it has contractual assurances in place. Oh, this is fancy.
We want to have a fancy microphone.
It's better
Carry
for-
on, carry on.
Okay. That it has appropriate contractual assurances in place with its processors. You as customers of AWS are by and large controllers. So what does that mean? As a controller, you determine the purpose and the means of the processing. Processor, this seems circular, but it's anyone who processes personal data for the controller. In most cases, the controller will also be the processor. If the controller, though, is using a third party for processing, then that third party is the processor. Processing itself,
The third arm.
this is great, thank you. Okay, thanks. Okay. All right. You know, the last guys didn't have a microphone. Okay, okay. All right, I promise I'm not going to sing. Okay. Processing is very, very widely defined in the legislation. It includes a whole host of information, of activities that we wouldn't typically think of as processing, storage, if personal data is made available, the possibility to block personal data, erase personal data, or destroy data. Those are all within the definition of processing. It encompasses a wide variety of activities. All right, so here are the principles that you as data controllers must ensure that any data processing complies with. Processing needs to comply with the principle of fairness, and processing of personal data can only be for a specific purpose. You have to ensure that the processing is adequate and that the processing is relevant to the personal data transferred to the processor. You have to ensure accuracy of processing. The data is destroyed when it's no longer needed. And then key for our customers, that there's adequate security in place and that transfers are legal and adequate. Transfers of personal data. Which brings us neatly onto transfers outside the EU. Personal data cannot be transferred outside the EEA without there being, quote unquote, adequate protection. So currently, transfers can be made to any of the EU member states, to the members of EFTA. Oh, before I move on, so the UK, this is asterisk for now, given Brexit, the UK has stated that it will implement the GDPR. However, the European Commission hasn't made a decision or an announcement of whether Britain will be determined to be inadequate, whether Britain will have a level of protection that's adequate to satisfy European data protection legislation and requirements. So members of EFTA, you can transfer to EFTA countries. You can also transfer to jurisdictions where the European Commission has made what's called an adequacy decision. If you go onto the European Commission website, it sets out the countries where the European Commission has determined, because of the laws they have in place, there's adequate protections for personal data in those legal regimes. It's an odd assortment of countries, but it works. We have yet to set up a region in the Faroe Islands, but who knows? AWS grows fast. If you're transferring outside the EU, you first need to think about, what does a transfer mean? Obviously, if you use a region outside of Europe, you're transferring to a region. Some member states also deem a transfer to have occurred, even if it's just potential access by a person or an entity outside of Europe. So even though your data resides in the EU, if there's the potential for access by a person outside of Europe, that is a deemed transfer. So, I don't know who that is. Sorry, this is not my laptop. But Federica needs to go away. And now that happened. Oop. So, can we just ignore her for a moment? Sorry about this. So, as a controller, you have to ensure that there are adequate safeguards if you're going to protect any transferred personal data. How do you do that? Engage in due diligence. Check out the audit reports. Check out certifications. Check out the industry standards that apply. Also, for countries where there hasn't been an adequacy decision, enter into a contract with your processor that includes the standard contractual clauses. Those are also referred to as the model clauses. You can also use, if you're transferring to the US, if the company, the US company is registered under the EU-US Privacy Shield, you can transfer to the US on that basis. Again, another asterisk, health warning. To date, the European Commission has not found, well, let me say it the other way. To date, this constitutes a valid mechanism under which you can transfer personal data. As you may know, the Privacy Shield replaced Safe Harbor. Safe Harbor was challenged in court as an invalid means, an invalid mechanism. Privacy Shield was adopted thereafter to replace Safe Harbor. So far, so good under Privacy Shield. Oop, okay. So, we've gotten the key concepts out of the way. What does this look like for you on AWS's customers? First, we need to think about the nature of the AWS services. I'm sure you're all very familiar with our services. Sorry. And, but from a compliance perspective, it's important to keep some key attributes in mind. Our IT infrastructure services, for example, virtual server instances and storage, are self-service, automated, on-demand, and flexible. We provide the data centers, but you, our customers, control how they use and configure the AWS services through API calls and through the management console. You are in charge of designing and architecting your solutions and how they run on AWS. So, customers are empowered to, as I said, architect your solutions, design them, determine how you're going to use AWS, configure your controls and your firewalls, how it is and who it is that can access the management console and the AWS services, and who can upload content via the console. You decide whether or not to implement encryption. And if you do, is it full encryption? Is it just for content at rest? Is it also in transit? Set up things like archiving frequency. Set up also internal policies and procedures, password controls, authentication controls, which level of personnel can actually access the console. For your end users, the extent to which end users can use AWS services or upload data to the AWS website. And then, in addition to your security controls, determine how you're going to back up your content. Are you going to replicate to another region? Are you going to maintain copies in-house, on-prem? There's a note on encryption. Just by encrypting does not depersonalize personal data. It's a technical or organizational measure, what's called a TOM, to protect the personal data, but even encrypted data remains personal data. So for example, if you're transferring encrypted data outside the EU, outside of Europe, you need to ensure that you use the model clauses if you're transferring to a non-approved country. So, I bet a lot of you have seen this slide before. So, you have. This is our shared security model, for those of you who haven't seen this. And so when you're looking at the security as a controller of personal data, and you're evaluating the security of cloud services, in our model, you need to understand and distinguish first between the security measures that the cloud services provider, in our case, us, AWS, implements and operates. We refer to that as security of the cloud. And then the security measures that you, as customer, implements and operates relating to security of your content and the applications that make use of our services. We refer to that as security in the cloud. So when we talk about the security of the cloud, AWS operates, manages, and controls the components from the host operating system and virtualization layer down to the physical security of the data center facilities. While AWS manages the security of the cloud, security in the cloud is the responsibility of customers. Customers retain control of what security they choose to implement to protect their own content, their platform, the applications, the systems and networks, no differently than they would for applications that they kept on-prem. So, typically our customer security strategy stretches across 3 pillars: visibility, control, and auditability. Let's talk about visibility first. The AWS console, the management console, provides immediate visibility to your entire infrastructure, enabling customers to audit their own environment. You can use CloudTrail and AWS Config to get a granular insight into how AWS resources are being accessed and changed. This level of transparency is virtually impossible when you're in an on-prem solution. Second pillar is control. You always control the location of your data. When you create an instance or a bucket on AWS, you must specify where it will reside, what region. Once created, only you, the customer, can move it. AWS won't change the geographic location of your content. And as we just talked about, under the shared responsibility model, you have clear ownership, as between AWS and you, as to security implementation. We maintain the security of your infrastructure. You maintain the security of your workloads. And the final pillar is auditability. So in order to demonstrate the compliance of the cloud, our services, and us as a business, AWS, is subject to audits and certifications according to global best practices and government standards. We've successfully completed audits and certifications, including the SOX, Security Organization Controls 1, 2, and 3, as well as numerous ISO standards. Our compliance program descriptions are posted publicly on our compliance website, and detailed audit reports are available to customers and potential customers, subject to them entering into a non-disclosure agreement with us. Hello. Content, so now we're circling back, getting those key concepts and how it all works within the AWS model. Content versus personal data. Content, anything that you as customers upload to AWS is content. So that could include data, it could be software, images, audio. It could be objects stored in S3, files that are sorted on EBS, and the contents of an Amazon DynamoDB table. Personal data is a very specific definition. Information from which a living individual may be identified or from which an individual is identifiable. So personal data includes the obvious things like names and email addresses, also includes national insurance numbers, social security numbers, payroll ID numbers. Should also note there's a line of recent cases in Europe that have determined that in some cases, IP addresses can be personal data. Content might include personal data. Personal data would be a subset of content. We at AWS don't know whether you have personal data on us. We don't want to know either. We apply the same security across the board to all of our customers. So here are some more concepts. Data subject. That's the individual who is identified or identifiable via the personal data that you as a controller hold. The controller, that's in most cases, that's you, customers. It's the party or the person or the entity that determines the purposes and the means of the processing of personal data. The processor, the person or entity who processes data on behalf of the controller. There are key requirements in relation to the security of content and data breaches. The controller has to ensure that there are appropriate technical and organizational measures, again referred to often as TOMs, to protect any personal data it holds against accidental or unlawful destruction, loss, alteration, disclosure, or access. As the controller, it's for the customer to determine what level of security is appropriate for the content they store and process using AWS. As we described, as I described a few slides ago under the shared security model, customers control how they configure their environments and how they secure their content, including whether they will encrypt their content at rest and in transit. They also customers determine who gets to access that content, what credentials are required for that access, as well as what additional security features and tools they use and how they use them. As I mentioned before, we don't know whether customers are uploading personal data to us. We don't want to know. I refer to it as AWS being content agnostic. AWS offers the same high level of security to all customers, regardless of the type of content being stored or the geographical region in which they store their content. So since we don't know what's being submitted to AWS or uploaded to AWS, we treat grandmother's recipe for casserole the same as we treat the most highly confidential and proprietary inventions and patents, for example. We're vigilant about our security and our cloud environment, and we've implemented sophisticated TOMs against unauthorized access. The TOMs can be validated through our certifications and reports, including the SOC 1 and SOC 2 reports, our ISO 27001 certification, as well as our PCI DSS attestations and compliance reports. Since customers are in control of their content when using AWS, customers are responsible for monitoring their own environment for privacy breaches. You need to know that in case you have an obligation to notify a regulator or a data subject under law of a data breach. How can you do this? You can set up your console using CloudTrail to get visibility and to get CloudTrail logs that will provide visibility into user and resource activity. This CloudTrail will notify you of pings to your accounts, which users and accounts made calls on your account, the source IP address from which the calls were made, and when the calls occurred. So using the logs, you can look in, and if there's an IP address that you don't recognize, you can then do some background investigating to determine whether a data breach has actually occurred. So transferring content. Customers decide where their content will be stored. The AWS infrastructure is built around regions and availability zones. A region is a location where there are multiple availability zones. Availability zones consist of one or more data centers. AWS currently has 3 regions in Europe: Ireland, the UK, and Germany. This setup allows customers with specific geographic regions to establish environments in a location of their choice. For example, AWS customers in Europe can choose to deploy their AWS services exclusively in the Germany region. Customers may choose to transfer content that includes personal data cross-border. We, AWS, offer customers a data processing addendum that includes the standard contractual clauses, often referred to as the model clauses, that apply where a customer transfers data from the EEA to a country outside the EEA. You should know the EU regulatory authority, the Article 29 Working Party, has approved the AWS Data Processing Addendum and the model clauses. This approval means that customers who require the model clauses can rely on the AWS Data Processing Addendum as providing sufficient contractual commitments to enable international data flows in compliance with the EU Data Protection Directive. In addition to the AWS Data Processing Addendum and the model clauses, customers who wish to transfer content that includes personal data from the EU to one of our US regions benefit from AWS's participation in the EU-US Privacy Shield framework. Amazon.com Inc. is registered under the framework, and the benefit of that registration covers certain of its affiliates, including AWS. So on to the hot point. So you're thinking, this is all great, but what about the GDPR? As many of you know, in 2016, the European Commission approved and adopted the General Data Protection Regulation, the GDPR. GDPR is a new data privacy law, and it's intended to harmonize data protection laws throughout the EU by applying a single data protection law that is binding throughout the EU. Now, it's unclear whether that will actually be successful, since there is rulemaking authority that is granted to national supervisory authorities, and those rules can provides quite a bit of discretion to the supervisory authorities. So we may well end up in a situation not that different from where we are now, which is, again, you cross the border into a different country in Europe and different rules apply. The intent of the GDPR was same throughout Europe. If that happens, that would be great, but there's some skepticism of that actually happening. The GDPR will replace the directive, and it comes into force on May 25th, 2018, just over 7 months away. Although conceptually the GDPR covers the same concepts and principles that are currently in the existing data protection directive, there are some significant differences. Firstly, it has extraterritorial effect. So it applies to controllers and processors who are established in the EU or who provide products or services to the EU, in the EU, or who provide products or services to data subjects in the EU, or who monitor behavior of data subjects in the EU. So it's hard to think of a company that operates on a global basis that will not be caught by the GDPR. And most companies don't realize this, which is why we are very much encouraging our customers to look at their processes and assume that they need to comply with the GDPR. So, how can you prepare for the GDPR? So again, we're looking at the compliance of the cloud and compliance in the cloud from a GDPR perspective. For the compliance of the cloud, we can confirm that all AWS services will comply with the GDPR when it becomes enforceable in May 2018. Additionally, AWS has also recently announced compliance with the CISSP Code of Conduct. CISSP is an organization. CISSP stands for the Cloud Infrastructure Service Providers in Europe. The CISSP Code of Conduct is an important tool for helping cloud customers assess how their cloud infrastructure provider complies with its data protection obligations under the GDPR. When we turn to compliance in the cloud, under the GDPR, with respect to transfers of personal data outside the EEA, we have a new data processing addendum that meets the requirements of the GDPR. This GDPR DPA is available on request on our compliance website to help AWS customers prepare for May 2018. although it won't become enforceable until May 2018, as I said, we're encouraging customers and partners to start preparing for the GDPR now. Here are some of the key points that you should consider for GDPR compliance. Data subject rights. The GDPR enhances the rights of data subjects in a number of ways. For example, data subjects have the right to object to the processing of their data, and they have the right to data portability. You'll need to make sure you can accommodate the rights of data subjects if you're processing their personal data. DPIAs, data protection impact assessments. You may need to conduct, and in some cases you may need to file with the relevant supervisory authority, a data protection impact assessment that describes your processing activities. The DPIA will need to identify your data handling procedures and processes, as well as the controls that you have in place to protect personal data. For those customers that have already implemented a high bar for compliance, security, and data privacy, the move to GDPR should be simple. For those who have yet to start that journey, again, we urge you to start now. Review your security, compliance, and data protection processes to ensure a smooth transition in May 2018. Sorry, let me and I'm just finishing. So and then there's loads more information available on our compliance website. So please check out the materials available there. Okay, thank you.